of going back on the record, sort of. Which, by the way, with just so you know, with the Supreme Court's most recent AO, at least as of June 21st, we're probably going to stop the live streaming because we'll all be back in the courtrooms. We'll probably be doing, at least in Collier County, we're likely going to continue doing civil motion practices remotely, but the judges will be in the courtroom, and we'll have more opportunities to appear in person as necessary.
Okay.
Just want to give you that heads up. All right. So was an agreement reached?
Yes, Your Honor. I will be sending Mr. Popper a settlement agreement shortly for him to review, sign, and send back. We'll get it filed with the court, and of course the order approving, so that we can proceed with getting the trial removed from your docket.
Very well. All right, Mr. Popper, you're satisfied that you've reached an acceptable arrangement with plaintiff's counsel?
Yes, Your Honor.
Very well. All right, so as she indicated, sir, she'll be sending you a settlement agreement. Now, one thing you should be aware of in the settlement agreement, no one should you understand, is there is almost always a clause within the settlement agreement that if you fail to live up to your end of the bargain, they're entitled to a default judgment. You understand that?
Yes, sir.
All right. All right, well, thank you both very much for your time.
Great.
And I look forward to receiving the settlement and the order adopted.
Great, thank you. Have a good day.
All right, thank you very much.
Popper.
Oh, I'm
Your
sorry.
Honor, may I
Before you go.
Go ahead, sorry.
Before you go, two things real quick. Until I receive the settlement agreement, I'm going to leave the current trial date set, okay?
Yes, sir.
But I just want to make you both aware of that. I'd rather not take that off the docket until the settlement is received. So right now we've got a trial date of, let's see, where's my order?
July 14th.
Was it July 14th?
Oh.
So as long as
Yes, Your Honor.
so as long as I receive that before July 14th, we'll be fine. But otherwise, I'm going to leave that set until that time, okay?
Yes, Your Honor.
All right.
Thank you.
All right, thank you both. Yes, counsel, you had a question for me.
Yes, Your Honor. If I may, about the AO that you just stated. Well, not that one in particular. The one that the 20th Circuit Chief Judge had to issue per the Supreme Court's order on case management plans.
Yes.
So you do handle like the county court cases as well, not just small claims cases.
I do, but we do have a civil division, and Judge Martin handles the bulk of them. But I do have a handful of the CC cases. Yes, ma'am.
Okay, I'm not sure if you'd be able to provide me some direction, because the proposed case management plans, and excuse me if I'm not using the right terminology, because all the circuits have different orders, So I guess my question is that we are required to serve the order with service on a defendant in a new case, but it has it already checked off as an expedited case. Are we required to leave it selected as an expedited case, or could we check like a general case?
That is a question I don't know the answer to. We are just now implementing the new case management plan, and we're trying to figure out how that works best. The judge that I would send that inquiry to would be Judge Martin.
Okay.
She was most involved in the planning and preparation of the county court case management plan, because she has the bulk of those cases. So you might want to direct that inquiry to her office, and she might be able to provide you with some guidance.
Okay, I will do that, and that does help to narrow down who I should reach out to. So thank you, Your Honor, for that.
Yes, ma'am. No problem.
You have a great day.
You too. Take care.
Morning, Your Honor.
Good morning, counsel. How are you?
Good. How are you?
Doing well. All right. You're a couple minutes early. So
No problem. We can wait.
wait for the defendant. I do have a question for you.
Absolutely.
We have a motion for summary judgment filed, which is what we're set for today.
Yes,
But I'm looking at the pretrial tracking sheet, and it said the defendant failed to appear.
failed to appear. I saw that also. To be honest with you, we didn't have our affidavit of damages, which is why at the time we didn't submit it. And then by that time, it had just had gotten crossed, so we just set the MSJ for hearing.
Okay. All right. Fair enough. That answers my question.
In the event that the defendant does not show today, I would still rather you rule on the merits based off of the MSJ or MSD as opposed to just a default. So this way it's a little more difficult to vacate if they try.
Fair enough.
Thank you.
In that case, let's then give the defendant a few more minutes to appear.
Absolutely.
I'm not going to go anywhere, but I am going to mute my microphone for just a moment.
No problem.
All right. It's 9:36. Defendant's not present. I believe they were properly noticed for today's proceedings. So counsel, I'm ready whenever you are.
Thank you, Your Honor. So this is a matter of purchase debt. The original creditor was Citibank here. The car was allegedly opened back in July of 2016. There were a variety of payments and purchases made on the account throughout the lifespan of the card being open. Once no more payments were made, the account did get charged off. That was January of 2019. And then my client is the one that had purchased that debt from Citibank. So I did have an opportunity to check the docket. It was just a hardship merely indicating, an inability to pay and things that had happened in the defendant's life. There's also been no opposition that's been filed to date at checking the docket just yesterday. So we are finding no genuine issue of material fact. I want to ask the court to grant judgment for a principal amount of $4,483.57. Court costs in the amount of $370 for a total of $48.53.57.
Was there an affidavit of costs filed?
I believe no, Your Honor.
All right.
We would submit that if you do grant judgment with the final judgment package.
All right. I reviewed the motion for summary judgment as well as the attached exhibits. I do find that as a matter of law, the plaintiff's entitled to judgment being sought. Award will be amount of $4,483.57 in principal. Costs will be awarded with a supporting affidavit.
Absolutely.
And you're not seeking attorney's fees or prejudgment interest, correct?
No, we would not be.
All right, very well. Please send me the proposed judgment along with the affidavit, and I'll get it taken care of.
Absolutely. Thank you very much, Your Honor.